Welcome once again, dear colleagues. My name is Msiment Alex, and today I'm going to take you through vitiating factors. We are going to appreciate what are vitiating factors. How do these vitiating factors affect the validity of a contract, and at what stage can we say that this kind of vitiating factor has actually affected uh, the contract at hand. Uh, let's first appreciate the definition. What are vitiating factors? Vitiating factors these are factors that that makes an otherwise valid contract invalid. They invalidate the contract that was initially valid. That means you had a valid contract with all the elements that makes it valid there, but because of certain circumstance, because of a certain factor, the contract at the end of the day becomes invalid. You need to know that these vitiating factors are provided for under Contract Act, specifically under Section 12, which provides that free consent of the parties is taken to be is taken that consent of the parties is taken to be free if it is not caused by the following. We have coercion, undue influence, we have fraud, misrepresentation, and mistake. And those are what we call the vitiating factors. And today, basically, I want us to look at mistake as one of the vitiating factors. Mistake is also provided for therein and there under section 12. It is also under section 16 and section 16 and 17. That is what I want us to appreciate. So today, let us actually first begin with types of mistake. What are the types of mistake? Number one, we have common mistake. Number two, we have mutual mistake. And number three, we have unilateral mistake. Common mistake, mutual mistake, and then unilateral mistake. You need to know that how we understand mistake under the law is not what the layman understands of a mistake. Mistake under the law, especially under contract law, is kind of different from what people outside there think as mistake, and that's what we are going to appreciate at this point. What is the mistake? A mistake is misapprehension, is misconception, is misunderstanding of the fact, is misunderstanding of the main term, is misunderstanding of the state of affairs relating to the subject matter of the contract or relating to the main subject of the contract. That is very important that we need to appreciate from the onset. Mistake is misunderstanding. Mistake is misapprehension of the state of affairs relating to the subject matter or relating to the major subject of the contract. You need to know that according to Lord Atkin, in the case of Bell versus Liverbros, Lord Atkin stated that mistake as to identity of the contracting party or existence of the subject matter operate to negative or nullify the consent. So specifically, what maybe that we also need to appreciate is that these vitiating factors, they all relate to the element of a valid contract, which is called consensus. Consent, like consent. Did you consent? or you were mistaken? Did you consent, or you were misrepresented, or whatever? That is what we are looking at today. And I want us to also appreciate that Section 12 provides for mistake. And let me now take you to a types of types of mistake. As I earlier said, we have common mistake, mutual mistake, and then unilateral mistake. What is the effect of mistake to the validity of a contract? What is the effect of mistake to the validity of a contract? You need to know that, well, one, it makes the contract invalid. That is the effect of it. Once mistake, once there is a mistake as to the contract, then that contract becomes invalid ab initio, becomes invalid right from the onset. The contract becomes invalid right from the onset. All right, let's now briefly look at common mistake. What is a common mistake? A common mistake operates when both parties to the contract concluded uh, are all under mistake. They are all mistaken as to the same thing. What the other party is mistaken on or to is what even this party is mistaken about. Both parties are mistaken, share the common mistake. The two parties share the common mistake. So in short, uh, these were ruled by erroneous brief. These parties are all ruled by erroneous brief. They believe in something that actually is different from the main factor or from the real thing. That's what we are trying to mean. So a contract is void where there is a common mistake. That contract does not exist. That contract must be set aside. That contract becomes a void right from the beginning. That is very, very important that you need to know. When you read a case of Kautilya versus Hasty, you need to know that the House of Lords held that a contract was void where the parties uh, where the plaintiff actually sold the cargo of corn on board the ship uh, at the sea to the defendant, but unknown to the parties. Unknown to the parties. Note this: unknown to the parties, the cargo had become overheated and fermented due to bad weather conditions. This the plaintiff sold the cargo. The plaintiff sold the corn to the defendant, but unknown to both of the parties, this corn had actually fermented. Therefore, they were all mistaken. They didn't know what they were dealing about. They didn't actually know that what they were dealing with had actually perished or of that sort. That means that kind of a contract becomes invalid, just like the holding in the case of Kautilya versus says. That is very important that you need to know. In this case, uh, Lord Cranworth held that the contract plainly imports that there was something which was to be sold at the time of the contract, at the time of a contract, and something to be purchased. That is very important that you need to know. But no such things existing. I think the judge continues and say, I think the court of Exchequer Chambers had come to only reasonable conclusion upon it. That is what Lord Cranworth said in that moment. So what you need to know is that the seller, the action of the sale of the price for the price of goods would not succeed because the contract had actually been vitiated. You cannot sue and the contract that has been vitiated by common mistake to claim the price because that contract is normal. That contract has actually a been had actually not existed just because of common mistake. So a common mistake is made when or where both parties assume some particular state of affairs, whereas the reality is on the other way around. Is the other way around. What we believe in now, when we are executing the contract, is actually not what is in reality. Let's say, for example, I'm selling the car, but the car had been taken by the driver, maybe to pick something from somewhere. But on the way, the car got an accident and it perished free. But unknown to me and the person I'm selling that car, we just execute the contract. Then in the evening, I received the news that the car has been destroyed fatally. That means that contract has been initiated, and I can't claim for the price. That is the best example I can give to that effect. So that means where the parties contract and they agree, but unknown to them that the goods have been perished. That's what we mean by common mistake. So just like it was illustrated in that case of Cauteria versus Hasty, it gives you the best understanding of common mistake. That is the Rocas Classicus case on common mistake. Okay, so you need to look at section 16, subsection 1 of Contracts Act. It provides that where both parties to an agreement are under a mistake as to the matter of fact, which is essential to the agreement, then consent is obtained by mistake of fact, and the agreement is void. As long as parties are mistaken, then that contract becomes void. Abolishment. Very, very important, and you need to appreciate. Let's look at kinds of common mistake. Common mistake is divided into various categories. And number one is we have res extincta. And number two, we have res sure. What is res extincta and what is res sure? Res extincta, this simply means that the subject matter does not exist. The subject matter of a contract does not exist. That is very important. For us, just like I earlier gave an example in the case of Cauteria versus Hasty, here, under res extincta, the subject matter is no more. I even gave an example where we entered into a contract, but the car gets destroyed. The car was destroyed and it is no more. But for us, this side are executing a contract. That means that contract is void ab initio under res extincta. So, sometimes the parties enter into a contract and they are not aware that the subject matter to that contract is that is what we mean by res extincta. Then that means there is no contract. That means there is no contract. Where the subject matter has been destroyed, then there is no contract. You need to appreciate that. Let us take a look at the case of Gallo versus Gallo. It's a case of 1914, volume 30, TRR at page 531. So the two believing that they were legally married parties, the two people thought they were legally married. They made a separation agreement. Uh, you know the separation agreement. This is an agreement executed between a wife and a husband to that they should separate to live apart. So it was later discovered that the man's first wife was actually still alive, and thereafter the second marriage was invalid. That, in short, the marriage that they tried to separate, they are saying that they are separating, but the wife to that very man was still alive. That means this woman who is saying that we separate was actually not legally married under to this man. That means you can't separate what does not exist. They were actually trying to separate something that did not exist. Their marriage did not exist. They are separating the marriage that did not exist. That is what we mean by res extincta. Okay? So it was held that the separation agreement was void as it had been entered on the basis of the common assumption that the parties were married to each other. Further, a common mistake arises when, unannounced to the contracting parties, the subject matter of the contract has been destroyed or has been perished, as earlier mentioned. Go and appreciate that case of Garowe versus Garowe and the case of Kautiria versus Sesti. They will shed light on what we are dealing with. Maybe one more case to that. You need to look at the case of Stickland versus Turner. It's a case, Stickland versus Turner, it's a case of 1952. That case will actually also shed light. Now we can proceed and look at resure. What is resure? We are still dealing with types of common mistake. What is a resure? A resure technically means that the thing already belongs to the buyer. The best example here, I'm buying a laptop, but that laptop was already given to me by the owner. Let me take you to the locality of this example. We are, let's say, your father gave you land earlier before. Let's say under a will, under what? But later on, after some years, you didn't know maybe, but now the person comes saying, I'm selling this land. And unknown to you that the land belongs to you already, you start buying. Then you later find out that actually that land belongs to you. Then you are buying what already belongs to you. That is what we mean by this kind of mistake. You're mistaken. You don't know that what you're buying is yours. You don't know that actually the phone you are buying, someone already gave it to you as a gift or as a what. Let me give you another example. You have a birthday. Someone sends a gift through a person, through your friend. Then when your friend comes, tells you, please, I'm selling this. Let's say someone gives you a birthday gift of a car. And when someone brings it, he says, please, I'm selling this car. Then you start executing a contract to buy that kind of a car. You're buying what already belongs to you. That is what it means uh, by resure. So you need to know to go and look at the case of Cooper versus Phibbs, where a person agreed to take a lease of fishery from another, though unknown to the two that the fishery already belonged to the lessee. Very, very important. This person was getting a lease of the fishery. But this fishery already belonged to the person who was uh, getting that lease, who was the lessee in that context. That means there is a mistake of resure. What you're buying is already yours. That case of Cooper versus Phibbs, it gives you a light about that. It's a case of 18, it's a case of 1867, RR2, HR at page 149. You can read it, it will shed light. Another case from Nigerian jurisprudence, it's a case of Abraham versus Chief Orowa. Abraham versus Chief Orowa, it's a Nigerian case where the plaintiff brought an action to uh, set aside uh, a contract that was already uh, uh, sorry for that. The plaintiff brought an action set it aside. The action was already void because the transaction for the sale of land, that very land already belonged to that to the plaintiff. They had actually carried out the transaction under this case, but he had bought land that belonged to him, though he didn't know. He didn't know that the land already belonged to him, but for him, he's causing for the setting aside of that contract. So you need to know that the common mistake also roots from the doctrine of nemo dat quod non habet. Uh, that's the doctrine that you will appreciate more when you get to second year, first semester under the law of sale of goods. A doctrine of nemo dat quod non habet, that you cannot transact what you do not have. You cannot sell what you do not have. You cannot get into a transaction of something that actually does not belong to you. Eh? In relation to the cases I gave you, you cannot separate the marriage that does not exist. It's not there. What do you want to separate? It's not there. You cannot sell land that already belongs to you. Now rather you cannot buy land that already belongs to you. Now what are you buying? You cannot buy from yourself. Huh? So in regard to that doctrine, the doctrine of nemo dat quod non habet, you cannot buy or you cannot sell what does not belong to you. That is what you need to appreciate. Let's now take a look at another type of mistake, and that is common mistake. Common mistake, not common mistake, a mutual mistake. Sorry for that. Let's now look at mutual mistake. What is mutual mistake? Mutual mistake, yeah, this occurs where there is a misunderstanding between the parties and they are at cross purposes. The two parties are at cross purposes. For you think the state of affairs are like this, but the other party thinks the state of affairs is like this. And such kind of arrangement, such kind of a contract can never exist because parties, they are misunderstanding the subject matter. I'm selling you a car, for you think I'm selling Toyota. No, for you you're thinking I'm selling Benz, yet I'm selling Land Cruiser. That is what it means by mutual mistake. I'm selling a pen, but for you think I'm selling big, yet the other person knows that I'm selling, yet me you know that I'm selling a smile pen. So you cannot buy what you don't actually expect me to give you. You cannot. You cannot buy what actually you think that I'm selling you, or what you don't know that I'm actually selling. And I cannot sell you what you don't expect from me. That is what we mean by parties being at cross purposes. I want to take you to section 16, subsection 2 of Contracts Act, which makes the contract void, where the parties to it operates under a mistake as to the matter of fact, which is essential to the contract. That contract is totally void. Contract is totally void, and like we know, void contracts are unenforceable. You can't enforce a void contract. I know we appreciated that when we were in our first year, but in our first year, first semester, but you need to know that a void contract is a contract which is unenforceable. That contract remains unenforceable, and you cannot enforce it. Let's now look at the mutual mistake as to the identity of the contracting party. Here it is also important that you appreciate it and you know it. Where you are mistaken about the identity of the contracting party, then that one also becomes question becomes a question. Actually, mistake as to identity of the party, that one is under unilateral mistake. We shall appreciate that one after. Let us first appreciate mistake as to the identity of the subject matter. That's actually what I wanted to refer to. Mistake as to the identity of the subject matter. What is what is it here? Assuming A has two vehicles, as I earlier mentioned, A has two vehicles. A, he has Mercedes-Benz ML32 and Toyota Corona. A offers to sell his car to B, and B accepts to buy the same car at 40 million. Get clear the example I'm giving you. The contract is concluded as usual, because parties that is offered as what, then the contract is concluded. Later, it transpires that A was actually offering to sell Corona, but B expected to buy Mercedes Benz. Then that contract becomes void. That contract becomes void. I want to take you to the case of Raffles versus Michelle House. That case is a case of 1864 2H H and C at page 906. That case will give us the light on that. In this case, the plaintiff sold to the defendant the consignment of cotton, which was to arrive at XPLS from Bombay. So two ships called PLS sailed from Bombay in October and December respectively. So the defendant was given by December consignment, but he refused to accept the goods because he expected them in November. In November, he actually expected them in October, not December. When he received the consignment, he said, "No, I didn't expect this. I actually expected this consignment in the month before." So he rejected the consignment because of being at cross purposes. That is what we are looking at. Mistake as to the subject matter. So in this case, the court held that the agreement between the parties had thereby was actually dismissed because the contract was void to that effect. I think another case that will shed light, you go and read a case of Tamplin versus James. Tamplin versus James is a case of 1879, volume 15, Chancery Division, at page 215. Let's now proceed and look at another type of mistake, which is unilateral mistake. What is unilateral mistake? Unilateral mistake, this is a mistake where only one party is mistaken. Is a type of mistake where only one party is mistaken. And the moment that party is mistaken, then there is a possibility that the contract will become void. Eh, But only if maybe that party waives the rights. The party can waive the rights and accept the contract. But if the party does not waive the rights, then that contract can be set aside for unilateral mistake. So a unilateral mistake occurs when just one party is mistaken as to the subject matter of a contract, and the other one is okay with it. Let's say a good example I can give you here is I make a contract with you. I know that a good example I want to give. Uh, for example, um, we have these arrangements where one of the parties is mistaken. I will get an example as we proceed. So you need to go and appreciate section 16, subsection 3, which provides that the contract is void where one of the parties is mistaken or where one of the parties operates under a mistake. Very important. You need to appreciate these provisions. They will guide you as you progress with your law of contract. So section 16, subsection 3, provides that that contract becomes void where one of the parties operates under a mistake. So a unilateral mistake, as I earlier said, occurs when only one party is mistaken and the other party is okay with the contract. And such a mistake, or such the other party takes the advantage of the party in a mistake against him. It takes the advantage of him. So a unilateral mistake also, you need to know that it also negates consent. I have to emphasize it that these these vitiating factors, they rotate on consensus, on consent. As long as there is no consent of the parties, then we shall say that maybe there is a problem with this contract. And that problem can be the initiating factors. Let us look at a mistake as to the identity of the contracting party. How can how can you be uh, how can it affect the contract when one of the parties is mistaken about the identity of the other party? I will take you to the case of Candy versus Lindsay. That is the case that will guide us. In this case, a fraudster called Blackburn, a fraudster called Brancan ordered goods from Lindsay and company and gave his address as 37 Wood Street. He signed his name. He signed his name. He signed his name and looked like Brancleon. That looked like Brancleon and Company. So the plaintiff had not dealt with that company, but knew it by the reputation as having a business at 123 Wood Street. The goods were duly delivered for the rogues at the rogues address, that is 37 Wood Street. The rogue sold the goods. The rogue sold the goods to Candy. Actually, resold goods to Candy and did not pay Lindt and Company, who then sued to recover the goods. It was held that the contract between Lindt and the rogue was void because the plaintiff never intended to deal with him paying the correct seller. The identity of the rogue, we are looking at the mistaken identity. Kandi was mistaken about the identity of the rogue. Actually, Kandi thought that he was dealing with a prominent businessman around the town. So that is why we are saying that at the end of the day, the contract was the arrangement between Kandi and the robe was void because he or she, that candidate, never intended to transact with that person. Okay? That case will shed light, and you will also meet that case in the under the doctrine of Nemo that God non habit, as I earlier mentioned, that you cannot say what does not belong to you. The rogue did not have the title to the goods. The rogue did not have the title to the goods. And that's why we are saying that there was actually no contract between the rogue and and this last person. Even here we consider the first person, but under the doctrine of Nemodat, Sharor is considered the second person. Okay, so you will also need to go and look at the case of Ingram versus Little, where the rogue claiming to be Hanson, where the rogue claiming to be Hanson visited the plaintiff's residence in response to the advert and offered to buy the family car. They refused to accept a check. He told them he was the PGM Hanson, with the business at Guildford. You see now, this person is saying, please, I'm the PGM Hanson. Hanson was the prominent businessman around town. So they are actually mistaken about the identity of the rogue, thinking that this person is the other prominent businessman around town. So that case of, of Ingram versus Little will also shed light on that. Can we also go and look at the mistake as to signing of documents? Mistake as to signing of documents. Here, you signed a document, but you actually didn't understand the contents of that document. You sign a document, but initially you didn't understand the contents of the document. So that is what we call the pre of non-ist factum. The pre of non-ist factum. It is very, very important that you need to appreciate. So this is also a type of unilateral mistake which arises as to the nature of the document signed and or sealed. So as the general rule, a person is, you need to appreciate this. The general rule is that a person is bound. The person is bound to his or her signature. The moment you append your signature to a document, then you're bound to all the contents of that document. That is what we are looking at. However, you need to know that courts have looked at this rule as being hostile, and they tried to relax it as we shall be looking at. Because there are sometimes where you sign a document voluntarily, and there are occasions where you sign a document involuntarily. So those are two different occasions. So that's why I'm saying that courts have changed on the mode of looking at things. You will have to go and look at the case of Saunders versus Anglia Building Society. It's a case of 1971 SC at page 1004. A 78-year-old lady wanted to transfer the title to her house to the nephew. So the clerk, who was actually a friend to the nephew, knew of the intention. He prepared a document by which the house was actually transferred to himself, and this old woman, signed the document. So the lady's eyesight at that moment wasn't okay, so she could not read and appreciate the contents of that document. And at the end of the day, uh, actually the lower court ruled, gave its ruling, and there was an appeal even. So on the appeal, uh, court held that she actually intended to transfer the house, and actually she transferred the house. she intended to transfer the house, and actually she transferred the house. Therefore, the, the appellate court ruled against the old woman. Yeah, so you also have to go and appreciate the case of Lewis versus Clay. It will also shed light on that. You need to go and also look at the case of Kakande versus Nsimbi. It will also help you on that. Otherwise, uh, I want to appreciate you for the for paying